Today, we are talking about lease agreements. What exactly are they? Do you absolutely need an attorney to write one? And perhaps the biggest question of them all, is there such a thing as a truly bulletproof contract? At its heart, a lease is a simple binding agreement between the lessor, the person providing the property, and the lessee, the person using it. The document defines the terms for the use of a specific property for a specific period of time. Let's get the third question right out of the way. The one about the perfect lease. Does it exist? A lease can be well written, but irresponsible tenants, or let's face it, some landlords as well, will always find a way to will always find a way to test its limits or create 1001 excuses and reasons why not to follow documents they sign. While no lease is 100% bulletproof, at least it is in your power to make it better over time. And in today's video, I'll show you how I personally construct my contract. Now, before we start, my name is Felix. I am not a lawyer. This information is based on my own experience in dealing with lease agreements. You can hire an attorney licensed in your state to draft your final document, but you also have to understand this. No attorney or document can guarantee perfect execution of any contract. Now, when we are done with legal bullshit, let's get to real business. I will divide this video in 3 different sections. First one, the legal framework. Why do we need contracts? The second one, essential terms. What should be included in contracts? And the last but not the least, additional terms. Provisions on what happens if essential terms aren't followed. The legal framework and philosophy. First, remember that your lease is primarily limited and governed by state and local laws, in case with United States. These laws define what you can and cannot put into the contract. For example, in the state of Minnesota, landlords are obligated to send a security deposit letter within 21 days after tenants vacated the property. Law doesn't explain what property owners are supposed to do if tenant does not provide the forwarding address. But hey, law is the law and you have to abide by it. Your lease needs to be proactive. It should anticipate problems. Try to make the lease as if-then driven as possible. If the toilet backs up, then the following action must be taken by X party within Y days. When you compose a lease, you must write it for one crucial third party, the judge. No. Assume they know nothing about your property, which most likely they don't. You need to write the document so that a person with no connection to the property can grasp the events, understand the clauses, and easily rule in accordance with that document.
I'm done.
And, by the way, never underestimate negligence and the sheer ability for people to be, stupid. For example, one of my ex-tenants was claiming in court that they didn't damage the wall in hallway, as was claimed on their security deposit letter. Because they swore they thought it was a staircase. Like by some divine miracle, that fixed the hole in the wall they left while moving out. Just remember, if term can be misunderstood, most likely it will be used against you.
Ooh, that's a bingo!
Make sure you protect yourself from this type of ambiguity. And that is why after this occasion we added the simple phrase, property and all common areas, staircases, hallways, and whatnot. That is an example. My own leases, especially commercial ones, have evolved over time for this very reason. Every time a tenant managed to twist a clause or declare something different, I added a specific, unambiguous clause to the next version of the lease. Your lease should not be static. It should be a living document based on your worst experiences. Just make sure you do not include vague, subjective terms. Things like,
will maintain the premises in good neighborly spirit,
or
high communication standards.
none of these don't work well for anyone besides politicians.
I think I don't have to think about that. Now, I may have to think about it.
But these terms are meaningless in court. Stick to the quantifiable, objective rules. Now, let's break down the essential terms that simply must be included in every lease. Portion number 1, parties and property. You need to clearly define who and what. Who are parties to the contract? The full legal names and contract information for everyone involved. The lessor and every adult lessee. What is the description of the property? The exact street, address, unit number, and any property boundaries. Bottom line, define the space clearly. When is the agreement active? The terms of the agreement. State the precise start and the end dates of the lease.
A beginning, a middle, and an end.
And don't forget about renewal options. If there are renewal options, clearly detail the procedure and the time frame. The deadline for written notice to either vacate or renew is crucial. You will need time to find new tenants, right? Otherwise, the property will be sitting on the market without any renters. This is especially crucial for commercial properties as it is not that easy to find tenants for those. Then you'll have to describe payment arrangements as well. Quite important, isn't it? What must be included? The specific monthly amount and the due date. It also won't hurt to specify how payments should be made, just in case. Do you prefer checks, electronic payments, or cash? Late fees. A clear, enforceable fee structure for late payments that complies with your state's maximum allowances, or whatever you agreed to. Just make sure you check the maximum limit of your state or city. Security deposit. The amount, where it is legally held, and the specific itemized conditions for its return or withholding. Neither do leave utilities without attention. Clearly state who pays for what: water, electricity, gas, trash, HOA fees, etc., etc. It is a shared meter. How is the cost split? Write it out in contract. That helps out a lot. Also, do not forget to talk about repairs and maintenance. Define the split, who is responsible for what. Usually, the lessor or landlord handles major structural issues, while the lessee handles minor interior repairs, yard maintenance, and routine cleaning. Just make sure they know about it. It's not as obvious to some people. Now that we covered the basics, let's talk about the worst case scenarios. This should be in the next section of the lease. That is your shield against major disputes. And these may be the difference between a quick resolution and expensive court battle. Let's talk about what happens if clauses. First, we need to talk about breaking the rules, or default and remedies in lawyer language.
Ma'am, I was already a blood-sucking parasite. All I needed was a briefcase.
One of them is material breach. Your lease must clearly define what a major violation is. This is not just being late on rent once. This is a non-payment, running an illegal business out of the property, or causing serious intentional damage. The fix-it window. If they break a rule, you can't just throw them out. You need a notice to cure it. This is the mandatory time frame, say 3, 7, or 30 days. That's the defaulting party has to fix the problem after you send them a formal written notice. The next step. Only when that fix-it window expires without resolution can the lessor legally move to evict or terminate the lease. And this process must be followed to the letter. Next up is controlling risk. Things like insurance, pets, gas, tenant insurance. You should always require the lessee to carry renter's insurance. This is cheap protection for them, covering their stuff, by the way, oftentimes not just inside the apartment, and it also shields you from some liability if they cause an accident. We had a video about pets in the past, but if you allow pets, be specific. Clearly list any breed or weight restrictions and make sure you detail any separate pet fees or deposits. Also, do not forget to put section about guests. Don't let a temporary guest turn into permanent unauthorized tenant. Define the maximum number of nights a visitor can stay before they are officially considered an authorized occupant. This helps a lot, by the way. Been there, done that, helped a ton in the eviction court. Finally, part about assignment and subletting. You must state clearly that the tenant cannot assign their lease or sublet the space to someone else without your prior written permission. This is not negotiable. It ensures that you get to vet and approve every single person who occupies your property. That is how you control the property, the tenant, and protect your lease. A well-constructed lease acts as your preventative measure. It makes the expectations and the consequences crystal clear for everyone involved. Do not rely on cheap generic boilerplate forms. Your lease must be customized to your specific property, your state, and unique conditions of your rental. Remember, let every bad experience improve your document. And do not forget that no one knows your property and your tenants better than you do. As for attorneys, use them at your own discretion. If you have a spare couple thousand to spend on some theoretical exercise on paper by a person who isn't guaranteeing its execution, knock yourself out.
I myself am more open-minded.
By the way, none of what was said in this video is legal advice. Remember? As always, be good people, stay away from stupid, don't let it occupy your mind, and I'll see you in the next one. Bye. If they